some of these areas where I don't want you to go forward through the rest of the topics that we're going to be addressing without at least these foundational distinctions being made. So I think we've cleared up what I hope are some of the definitional differences and issues now between clinical and forensic, or clinical forensic psychology, which really often focuses on assessment and or treatment in a legal context, or individual assessment and practice that serves the legal system. In the non-clinical, you generally do much more broad examinations of phenomena or assumptions that underpin the law, studying things that shape and influence your perceptions and your behaviors. And so over lunch, some of us were having a chat about some of the differences in perception that can be generated by belief systems or contextual systems or just individual experience. Even if you're exposed to exactly the same objective facts, there's still all of those subjective issues, and that's a topic that psychologists have studied as well. But generally trying to provide more of an information database from the psycholegal sphere then that can inform legal changes and reforms. Just to pinpoint a few more of the differences in the values, I think the notion about objective truth is one that gets bandied about in many ways, and we constantly are going to be grappling with, and the psychological approach to it is usually a much more probabilistic one. Certainly when I practiced law and had some dealings, for about 10 years I worked as an administrative judge, hearing cases, and when people came into my courtroom and said they were looking for truth, I always used to quake a bit and say, I think we're dealing with justice here, and trying to give them a lecture on how there might be differences between truth and justice, and my psychological hat was corking around, trying to figure out how to answer these questions because fact finders would have a clear demand of what they expected in the legal setting, but all these disciplines deal with these values somewhat differently, and so finding a right answer and or the right institution for the kinds of answers that you want is not always straightforward. Oftentimes in the adversarial system, there's a lot of pressure on winning, on who's going to be the victor in an adversarial process, whereas psychology has been much less interested in that, is just interested in knowledge and understanding, and that doesn't fit necessarily with what the law wants in a particular case. I've mentioned some of those, political, attitudinal correlates that go along with each of the disciplines. But also, we have to grapple with the fact that if you are going to be using an empirical legal studies kind of approach, that can be seen as very threatening to the traditional doctrinal approach or some of the authority that the law has typically had. And so there may be a fairly uneasy relationship at times between social science and the law in terms of who really has the authority. And so we are going to talk next about different ways that you can approach using psychology and law in the legal system that helps to address that kind of conflict. And I want to find my slides on those points next, which are out here. So when I speak about myself as a legal psychologist or other people doing legal psychology in an empirical legal studies way, we're usually addressing three major dimensions. We're either applying research and focused only on the research sphere, or we're focused on the practice sphere, or the policy development sphere. But the applications that we do in any of those spheres can be done at different levels. And I think it's really important before we go forward for the rest of the week to make sure that you understand that we can have psychology functioning in the law, or we can do legal psychology where it's described as psychology and the law, and then a third version, which is psychology of the law. And those tiny little words make a huge difference to the enterprise and the activity. So it's worth spending a little bit more time today on unpacking those and making sure that you can generate your own examples of each of those as well, because no matter what the empirical discipline, I think you can do it at any of those levels. And I think that there is a difference in the extent to which there is really a value or traction from them, depending at the level on which you approach the problem. So the most common is psychology in the law, or if it were another discipline, sociology or political science in the law. And I've given you a few examples there. You know, that's very much where you see most often the forensic clinical psychologist in action, or a psychiatrist in action, and they might focus, for example, on the mental state of the accused. They might focus on problems such as the suitability of a particular parent in marital dissolution over custody issues. They might focus on the accuracy and all of the issues affecting perceptions of a particular eyewitness and the particular events in a particular crime that might have made eyewitness evidence more or less accurate or fragile. In those situations, you often have the psychologist appearing as either a consultant or sometimes going on through to become an expert witness in a trial. And the focus is on how psychology can serve the law in particular proceedings, pre-trial or at trial. Okay? So compare that with what I mean when I talk about psychology and the law. Usually here, we're looking at different behaviors in the legal system in a bigger sense, not just within a particular proceeding. We're looking at research on all of the participants, not the accused in the trial, but maybe the lawyers, you know, maybe witnesses, judges, magistrates, victims, juveniles, and others, in a more holistic sense about the legal system. And some typical examples of the kind of research that addresses this level might be, what is the psychology of policing? So that you're looking both at policing as a discipline and using psychology to enhance that entire sort of system. Detection of deception is something that goes way beyond issues that are just focused on one particular case, you know, that might have a lot to do with how we understand and interpret what people are saying in social situations that generalize to legal situations as well. Witness recognition procedures that are implemented would be changes where psychology is adding to the law outside of a particular case. And I think I would probably put therapeutic jurisprudence also in the situation, but it might lap over into the next category somewhat as well. We can talk about that. But for those of you who are not familiar with it, therapeutic jurisprudence is a movement that looks at the notion that law should be a benefit to the litigants. It shouldn't just through the adversarial system, you know, dispense justice that doesn't necessarily benefit the parties, and particularly the litigants, but the notion is that it should have a therapeutic and therefore positive effect on them. So that's looking much more at psychology and the law than in. So the third level to distinguish is that called psychology of the law, and an example of that might be to inquire as to why it is that people obey or disobey laws. So you're really trying to see, you've got these laws set up in a certain way, do they then motivate people to obey or disobey? That would be using psychology to understand the legal system at a different level. And so some further examples of applications there might be inquiring about people's attitudes to penal sanctions to see what that does, attitudes to monetary compensation, if that's part of your legal redress system, attitudes to different types of offenders who are processed by the legal system and the kinds of ways that they're treated, the legitimacy of different policing processes, and I would also put in there some very recent movements dealing with, for example, deliberative democracy, looking at citizen engagement at a very broad social level to see whether it's valuable to have citizens engaged in notions of justice in different ways and how to engage them to deal with that aspect of psychology. So I'm going to unpack for you now, as an example, something taken from a jury study, because I do quite a lot of jury studies, and even though you don't have them here now, you used to. This example, I think, will just highlight what you might do if you are an empirical researcher and you were interested in, for example, the question of racial views or racial biases that jurors might hold, or fact finders might hold if you don't have jurors, or magistrates, or tribunals. How might you study it at those different levels? So if we were working at the level of psychology in the law, you might hire a trial consultant to aid the lawyer in selecting a juror or judges to avoid racial bias. Okay? So they would just be focused on that in the law level at one case. If you're interested in psychology and the law, you might engage in research that is much broader and studies how you should question people in order to get them to admit bias, because that's a whole different issue. And if if your issue is to screen out the bias, you need to be very good at identifying it. So what procedures are going to be most effective at getting it to manifest? If you were interested in psychology of the law, you might instead look at comparative systems in order to uncover why and how different practices emerged in different jurisdictions that were trying to establish impartiality in the fact finder, whether the fact finder is a judge or a juror or a magistrate or whatever. So you can see that the kinds of study and the kinds of level of engagement that you would have with these questions will vary very much depending on whether you're doing it at that sort of meta level or whether you're doing it within a particular case.
If you were doing the problem that we did before and we used this categorization, what would come in the law and what would come as and what would come as of?
Let's see if you can generate some answers to that question.
I mean, people did put out what they thought were basic issues, so I'm just wondering if you went back to the problem that you did and then sort of use this categorization, what would we use as in psychology in the law? Where is the psychology and the law playing, and psychology of the law? I mean, if we just did a parsing of our own discussion, I think maybe it kind of might just hit home harder as a system.
Yes?
Anybody? I want to put a hand up. Go ahead. Someone has to try.
I was thinking maybe psychology in the law, where you bring out the whole question of this impact of stress on the mother, or how the sibling rivalry, or all those kinds of questions would probably fall in the category of psychology in the law.
Yes, I would say that's true, because you would be focusing on that individual and that particular case, right? Okay, good.
And probably psychology and the law would be like the whole question that you were talking about, that how nutrition, this like the whole question of responsibility of the mother, how the society is looking at it, or how probably the jury looked at it, that it was placing a greater responsibility on the mother
the psychology of the law. Anyone else? Yeah. Yes.
In the microphone. Thank you.
Psychology and the law, we can, as it says, the research study how effective questionnaire. We can put postmortem depression in that slab, I feel. Postmortem is in a late research study where delivered mother undergoes a depression. So we can keep in the second slab of psychology and the law. And the third one, psychology of the law. The girl child can be kept out of the psychology of the law. I'm just assuming, as Indian Constitution law says, any child who does anything, any act below 7 years are exceptions, a general exception. So psychology of the law can be given in the stab of the child who have done some mischief innocently or with an intention, similarly privately.
I think those are good fits. I think I would agree. Other examples? Well done.
In respect of what Amazon said about the way you look at negligence when you're dealing with such an issue, I do believe such questions would come clearly for me within the psychology of the law. And my question also would be in respect of, if you look at sibling rivalry, which is largely the domain of psychology, right, and how that would affect an outcome in this case, would you characterize that as psychology and the law or of the law? Because I think it would fall within psychology and the law.
Yeah, I don't think it's off. I don't think sibling rivalry, I don't think is part of the law, but the negligence issue is. And so the sibling rivalry, if it were presented, just as a general study of how people behave, but not necessarily specific to that individual, and there's no assessment of her, that might be and the law at that level. It's possible that the sibling rivalry might fit as psychology in the law, depending on how it is presented and depending on how it is studied. So the topic itself, but rather the approach to it, is going to be the defining factor as to which level you're at between the in and the end.
Yeah, I felt that when we are kind of getting the individual expert to testify in a particular case, we are much more in this area of psychology in the law.
We generally are.
Yeah,
yes.
and when we are bringing in kind of a range of studies around postpartum depression, or we're looking at the impact of sibling rivalry on young, children, that entire body of knowledge, if we are using and trying to bring it in our argumentation or otherwise, I would see it as psychology and the law. And the question of the whole business of the patriarchal bias, the effect of, the manner in which you operate there, what your expectations of mothers are, what the way in which you kind of frame questions of negligence, I would see that much more as psychology of the law. I mean, I'm seeing it as three, because we discussed each of these, but if you put it in there, then I think you start to see, how they join in together.
I think that's really helpful.
Yeah, you have to place the entire concept of rely incompetence in the sense, will you place it in the law? Yeah.
I would put the whole question of incompetence and all, and on to say that, below 7 and between 7 and 12, the distinctions that we make, I will again put it as psychology of the law.
Yes, I think so.
Because when we're trying to question, as part of what we're doing in, say, post the disability convention, and you're starting to speak in terms of evolving capacities. So then, it is like asking to change the psychology of the law and start to acknowledge.
If you look at the entire exception chapter of in the IBC, you place that in
Right, and so you can see that if you want to have the greatest impact, really, on the law, the level at which you engage in your research and study is going to be very important as a choice. And so...
And we kind of fit into each other, no? In the sense, like what you find is when you're looking at, though you're using it is in the law, when you cumulatively look at that data, it then starts to create some of those research studies, and also for you to be making those meta-level kind of statements on psychology of the law. So they kind of connect with each other, and yet you might have them being done in very disjunct way also, because people don't make the connection.
That's right.
Yeah. So I'm sort of seeing this as, in some manner, very, very helpful in how to structure your data. You know, what is of importance, what you can put there, and then how they connect with each other.
Exactly, because I think that unless you can mount an argument within a case, you're going to have a very difficult problem of persuasion, and yet probably that is the level, you know, at which you can have the least impact, because you're dealing with one case at a time. You know, so I mean, for me, moving from legal practice to legal research, the allure was that as a practitioner, I could deal with one case at a time, and you just feel this is exhausting. I'm never going to do as much as maybe can be accomplished if I can have more of a systemic impact, and so I was very intrigued to move into a different phase of my career and do psycholegal research at a systemic level where I'm looking at the questions in a very different way, but driven by those same sorts of questions and based on my experience as a practitioner with the cases. So I think those interconnections are there, and it does need to be integrated. So thank you. All right, how are we for time? 15 minutes, okay. There are a couple of other follow-up issues that I think we can move to that are sort of just to wrap this up. But I think, this is really, this distinction between those three types is really a critical issue because of the misunderstanding and misperception that so many people have about really the level at which empirical legal studies and especially social sciences like psychology might have any impact. So I think it's really valuable to clear that up initially. So I'm going to jump back through some slides that we skipped over earlier to see if I can fill in some gaps. And I think this was where we stopped just a little bit on the legal psychology. We looked at some of the trajectory of empirical legal studies, but psychology and law has its own little history, and quite a few scholars in this area have worked on summarizing it. There's some wonderful publications about it if you're interested. And I just want to share with you a few of the highlights. I think the most strident difference between empirical legal studies that I've been outlining and legal psychology is that legal psychology regards itself as a discipline, whereas empirical legal studies does not. So we might consider why, but legal psychology regards itself as a sort of new discipline as much as neuropsychology or any of those other sub-disciplines that we've been highlighting. And part of that has to do with its history and the kind of training and practice that you would engage in if you are a legal psychologist. So these might be quite slippery distinctions between what is an approach and what is a discipline. But it's food for thought for us to consider. But clearly my colleagues regard themselves as members of a sub-discipline, training other people in the sub-discipline at all levels, from undergraduate through continuing education and postgraduate levels, and that's been the status for some while, even though it's taken a bit longer for the term legal psychology to get more consolidated and accepted. But it really, had its underpinnings with broad criminology and causes of crime, that you'll find common with criminology itself. And then there were individuals later on who focused on specific issues about the causes. Was it developmental? Did it start with juvenile delinquency? And what are the influences that are of a nature-nurture debates there? The impact of genetics and the interaction with environments, all of that work has continued and been very fruitful. Then we had a huge impact from Sigmund Freud, very much focused on the clinical dimensions with abnormal psychology, psychopathology, and much of that work has really been refuted and rejected by contemporary psychologists, but we still value all of what Sigmund Freud provided in terms of how it led the discipline to unfold. But some of the work that has been done today, even on detection of deception, really draws on some of the theories that were founded by people like Goodman. In the 1885 era, Hermann Ebbinghaus did individual studies of his own memory. He kept records in diaries of how he remembered and how he forgot things, and he produced graphs that turned out to be the models. A replication was done in the last year or two by some researchers, and exactly his findings from 1885 have been replicated today. So he was a very thorough and an eminent scientist who applied robust methods that have withstood the test of time and have taught us how rapidly we forget things. And I'll be elaborating a little bit on forgetting rates and forgetting curves that all come, in fact, from work that was generated long ago by Ebbinghaus. We still talk about the Ebbinghaus curve in psychology because it's so important in terms of getting good evidence and high quality evidence, and the notion that we follow now to treat memory a bit like forensic trace evidence, so that you want to capture it before those traces become corrupted over time, and so it's important to know that information. Alfred Binet did much similar work and focused on children's competency and reliability and suggestibility, and that work has continued until today. William Sturt did something similar with eyewitnesses. That has become very important as a dimension of legal psychology today, and legal psychologists will probably say that's the most over-researched area of all the areas in legal psychology at all. It was followed up on by Hugo Munsterberg, and the reading that we assign today is quite a lot about Hugo Munsterberg and his relationship with the legal profession. But he was famous for showing some of the errors that we make that are normative. The notions that we don't have perfect judgment and perfect systems of memory that lead to all sorts of unreliabilities that the legal system then has to deal with that impact credibility ratings. More contemporary work, involved, satirization of Munsterberg. Eyewitness testimony advanced again starting in the early 1900s and has continued through today, so that nearly every student who studies legal psychology gets a good foundation in that work. Burt did more work on the legal system and the psychology of it. Robinson was important in shifting the focus to lawyers as important legal actors to study psychologically. Then, there was a period of about 60 years where the major focus in psychological output was in the clinical sphere. In 1968, the American Psychology and Law Society was founded. It's also Division 41 of the American Psychological Association. And I, was a member from the time I first became a psych law student. And it was very important in my training, and ultimately, I think in about in the early 1990s, I was president of that association. And other countries have similar associations. So in Australia, as you'll have read, we have the Association of Psychiatry, Psychology and Law. So we draw in our psychiatric colleagues into this interdisciplinary activity in some areas, although the differences are more delineated in different communities. When I first began working in the Australian community, I was very surprised when I was doing some training for judges, when one of the judges really asked me quietly, what is the difference between a psychiatrist and a psychologist? Although he had been making many decisions over many years where he had appointed psychiatrists and psychologists as experts, he actually was quite befuddled about what the difference was between them. And I think that's very general. If you tell people you're a psychologist, they often think you do much what a psychiatrist does. And so, you know, you need to be a bit of an insider sometimes in these disciplines to be able to compartmentalize the way the skills and the training differ. And I'm happy to elaborate that further with you. And then in the 70s, there was much more of an emphasis in psycholegal studies on social problems, social relevance, that changed the emphasis of what people were looking at in the research that they did. Our flagship journal, Law and Human Behavior, has been running since 1977, but now there are many others that I'll share with you. And so from that period, I think applied psycholegal research really gained more acknowledgement and recognition as a discipline on its own. The types of journals that are very typical, that are interdisciplinary, that we would focus on and work that I consider major outlets would be journals on this list. And for a while I served as the editor-in-chief of the one at the bottom of the list, which has now got a very strong impact rating and is unique because it's both a law review, fully fledged law review with a typical, editorial committee of law students, as well as a peer-reviewed psych journal. So it really does mesh the two in a unique way. To finish up with some of the methodology issues that we touched on a little bit earlier, we focused a bit on what empirical legal studies methods might be, and I wanted to just show you how similar those were to really what legal psychology